Presiding with Honourable Mr. Justice Muhammad Ali Mazhar in this court. The current matter in this court is concerning with the downing of the flight VA143. The parties in this case are Rosenberg as the respondents. Have 40 minutes to present their case.
May it please the court.
Yes, please. Proceed.
Good afternoon, Your Excellencies. I am Alpha Malik, the agent for Adorivia, and I will be taking 19 minutes to present issue 1 and 2, while my co-agent Abir Umar will take for other 18 minutes to present issue 3 and 4, and 3 minutes are reserved for the third. Shall I proceed with a brief summary of facts? Much obliged, Your Excellency. The case at hand is about Adorivia's right to protect its democracy, sovereignty, and national security from unlawful interference by Rosenberg. After gaining independence in 2015, Adorivia committed to its democratic values. However, as it prepared for the elections, Rosenberg interfered continuously, spreading misinformation, launching cyber attacks, and deploying paramilitary actors to destabilize the process. Your Excellency, on June 29, 2024, a Rosenberg-registered aircraft flight VA143 deviated from its path and entered Adorivia's airspace without proper clearance. Despite multiple attempts to establish contact, it failed to respond clearly. The aircraft carried military personnel, diplomatic officers, and also leader of a terrorist group, MSRA. Given the security risk, Adorivia acted under the standard defense protocols and shot down the plane. Among the wreckage of the plane, Adorivia found some diplomatic documents proving Rosenberg's involvement in the internal affairs of Adorivia. These documents were temporarily retained for security review before being returned. After the elections, unrest broke out and Rosenberg arbitrarily detained the former Foreign Minister of Adorivia, Mr. Sahir Nishama, denying him his diplomatic immunity. Therefore, this case is now before the Honourable Court and the proceedings have commenced by the way of a special agreement. Your Excellencies, am I allowed to proceed with issue 1? Your Excellencies, issue 1 states that whether the documents obtained in the wreckage of flight are admissible in these proceedings. Your Excellencies, humbly submit that these documents are admissible, and for that we have two submissions. Firstly, the documents are obtained lawfully by Adorivia, and secondly, even if documents were illegally obtained, they still remain admissible in these proceedings. Your Excellencies, moving with the first submission, which has further two sub-arguments. Firstly, that Adorivia has obtained documents lawfully because they were not...
What do you mean by say lawfully? How it was obtained lawfully?
Your Excellency, moving with... I would answer your question within this first sub-argument. As per Article 27(4) of VCDR, the criteria for a diplomatic bag is that it must have visible external markings to indicate its diplomatic nature. However, if Your Excellency may refer to para 42, second line of the Moot compromise, it states that bag's identification markings, which were meant to clearly attribute it to Rosenberg, were severely damaged in the crash. Your Excellency, combined with the fact that Adorivia was not a receiving state, they were unaware of the presence of diplomatic bag on the plane. They were unaware that this is a diplomatic bag, especially when the markings were not visible, which is the criteria as required in Article 27(4) of VCDR. Your Excellency, this was also observed in the famous Deco incident, where authorities...
No, my question was the admissibility of that bag recovered from the wreckage of the flight. You started your argument that it is admissible evidence and it was lawfully obtained. So
Certainly.
What is the provision under the convention that it was lawfully obtained?
Your Excellency, that my second submission concerns the admissibility. First, I was trying to establish that they were lawfully obtained. If Your Excellency wants me to move directly to the second submission...
lawfully obtained. The word lawfully obtained, what do you mean by that?
Your Excellency, lawfully obtained means that they did not commit any violation of international law. It was not illegally obtained as alleged by the respondents.
Okay.
Your Excellency, in the famous Deco incident where authorities they opened a Nigerian crate even when it was declared as a diplomatic bag, which is not the scenario in our case, just because the crate was not marked as required by Article 27(4) of BCDR, and even the Nigerian Commission itself, they did not at any stage question the decision to search and open the crate. Your Excellency, therefore, due to lack of visible markings, the bag was not protected under BCDR and hence opening the documents was lawful. Moving on to the second sub-argument of this submission, which is that Adorivia's actions regarding those documents, regarding retaining or photocopying or scanning them, are justified because there was a state of emergency and strong national concerns. Your Excellency, this was demonstrated in the Lok affair when Italian authorities they opened an Egyptian suitcase which was declared as a diplomatic bag, that too just outside the Egyptian embassy, on the basis of state of emergency, and furthermore there was no Egyptian protest against it. So Your Excellency, in the case at hand as well, para 23 fourth line of the Moot compromise, if the Honourable Court may refer to that, in the case at hand as well, after the plane was shot down, there was a state of emergency, especially considered that there were credible intelligence reports about a potential hijacking of the plane and the presence of Ziauddin, who is a leader of a terrorist organization, in the plane, that further supports our stance as well. Your Excellency, to conclude this submission, we submit that while we agree that merely on the basis of suspicion opening of a diplomatic bag is not lawful, however, in this scenario there were not just suspicions, strong national security concerns. Adorivia was not a receiving state, the diplomatic bag was not properly marked, hence Adorivia's actions were completely lawful. Your Excellency, moving on to the second submission of this issue, which is an alternative argument if the court is not satisfied with the first submission. It is that even if, as the respondent alleges, that the documents were obtained illegally, they still remain admissible in these proceedings. Your Excellency, there are no formal rules of ICJ procedure that could limit the submission of evidence. In this regard, ICJ has always been flexible. The former president of ICJ, Peter Tomka, has said that, and if the researcher may assist, the rigidity. He said that, and I quote, "The rigidity of evidentiary rules found in some municipal legal system has not been transposed integrally into the international legal order. Quite the contrary, rule of thumb for evidentiary matters before the court is flexibility." Your Excellency, the general tendency of the court has always been to admit the evidence rather than declaring it inadmissible outright. This was also seen in Corfu Channel case, where UK relied on evidence that they obtained by violating the territorial integrity of Albanian waters, and even though ICJ did condemn UN's actions, they never declared those actions unlawful, and even some of the evidence was actually used within the judgment. So on the basis of that, we submit that even if the documents were obtained illegally, that's what the respondent alleges, they still remain admissible. And the second sub-argument of this submission is that the probative value of the evidence, it outweighs the manner in which it was obtained. Your Excellency, the documents must be admitted because they are crucial for these proceedings, as they contain evidence of Rosenberg's direct interference in Adorivia's internal affairs, which is actually the second issue. So to decide fairly on the second issue, we must admit these documents as they contain the direct evidence of that interference. Your Excellency, international courts and tribunals, they have used the principle of balancing of interest, where admissibility of illegally obtained evidence is concerned. I would quote the principle for Your Excellencies. This principle involves weighing gravity of the violation committed to obtain the evidence, which in our case is opening a bag which was not properly marked, and against seriousness of wrongdoing for which evidence is used, and that is Rosenberg's interference in Adorivia's internal affairs, violating principles of not just non-intervention but also sovereignty of Adorivia. Furthermore, Your Excellency, this principle also states that whether the evidence was obtained through an unlawful act specifically aimed at obtaining the evidence, or was it acquired incidentally during an independent act. Your Excellencies, in the case at hand as well, as stated in para 4, line 4 of the Moot compromise, it states that the documents contain direct evidence in Adorivia's internal affairs, hence they have a greater probative value in these proceedings. Also, Adorivia did not open the bag or shut down the plane just to get those documents. Adorivia was unaware of presence of those documents in that bag or in the plane itself. So the obtainment of evidence was just incidental to an independent act. Furthermore,
When you do not know that what was the evidence in that bag, then why it was open?
Your Excellency, we were not aware of the nature of the bag. We did not know that it is a diplomatic bag due to the markings that were damaged.
What was the curiosity then?
Your Excellency, as the plane was shot down, it was a crash site, and the investigation process, which is a standard protocol after a crash has happened, for the investigation process, we have to look at the premises of the crash site and whatever things are found in that crash site.
Why the sealed bag was not returned to its owner?
Your Excellency, it wasn't returned. It was returned to Rosenberg, but after reviewing those documents, as they
and making photocopies of that.
Your Excellency, I agree that Adorivia did make photocopy and scanned those documents. However, that was based on national security concerns, because those documents contained direct evidence of interference of Rosenberg in our internal affairs, and we scanned those documents so we could submit that in these proceedings so that the justice is maintained.
Normally the diplomatic correspondence in cipher language, cipher language, whether those documents in cipher language or in their own language of the two countries.
Your Excellency, I believe that facts of the case are silent on that. I would just conclude the submission by saying that Adorivia was not a receiving state. They were unaware of presence of diplomatic bags on the plane. They were unaware of the diplomatic nature of the bag on the basis that the markings were damaged.
So you opened it accidentally?
Certainly, Your Excellency. We did not open it accidentally. We opened it for investigation purposes after the crash has happened.
Okay.
And even if, as my second submission was about, that even if the Honourable Court is not satisfied with the first submission, even if they were illegally obtained, they still remain admissible in this proceeding, as was seen in Corfu Channel case. If the Honourable Court has no further questions...
You see, the matter depends whether the court is satisfied or not. It only depends on the law. What law you have cited for the admissibility of such documents.
Your Excellency,
we are not here to accept each and every evidence as the judges of the court. We have to see the law first, no? So if it is admissible evidence, of course it is admissible, and if it is inadmissible, then of course it is inadmissible. So
certainly,
your argument whether court is satisfied or not, court has to satisfied on the law alone. Okay? Please continue.
Certainly, Your Excellency, to answer that question, I would reiterate that in ICJ statute or in any ICJ procedures, there are no rules that would limit the admissibility of illegally obtained evidence.
That would be a good answer for the question. Okay, if there are no rules, then it is open to
the discretion of the court, and on the basis of Article 38(1) of ICJ statute.
And of course, it is for the other side to inform us whether there was some breach of rules or not. If you say that there were no rules, then obviously then there is no restriction on that. Is it your case?
Certainly, Your Excellency, we are relying, as there are no formal procedure rules, we are relying on the judicial precedents and scholarly articles as per Article 38(1) of ICJ statute. If the Honourable Court has no further question, may I proceed with issue 2 of...
Yes, why not? Please continue.
Your Excellency's issue 2 states whether Rosenberg's interference in the electoral process constitutes a violation of international law. Your Excellency, we humbly submit that Rosenberg's interference is a violation of international law, and for that we have 2 submissions. Firstly, it is violation of principle of non-intervention, and secondly, it is a violation of principle of self-determination of Adorivian people. Moving on with the first submission, which is that Rosenberg's interference violates Article 2.4 of the UN Charter. Your Excellency, Article 2.4 of UN Charter states that states should refrain from threat or use of force against territorial integrity or political independence of any state. Furthermore, in Nicaragua versus US case, this very court, they reaffirmed this principle in para 202 of the judgment, if the researcher may assist. The principle of non-intervention involves right of every sovereign state to conduct its affairs without outside interference, and international law requires political integrity also to be respected. Your Excellency, political independence of Adorivia was undermined due to the cyber attacks on the electronic voting machines of Adorivia. If the Honourable Court may refer to para 52 of the Moot compromise, it clearly states that electronic voting machines were attacked by a virus and only 93% of the cast votes were counted, which means that 7% of the votes were not even counted. And secondly, in para...
93% votes were counted.
Certainly, Your Excellency.
Only 7%.
Certainly, Your Excellency. In para 15 of the Moot compromise, an independent inquiry commission, they discovered that the virus attack had been orchestrated through a server that was located in Rosenberg territory. Your Excellency, now a point might be raised from the respondents that just because it originated from their territory doesn't mean that it is attributable to the state of Rosenberg. Your Excellency, for that I would like to refer to the principle of due diligence, which is crystallized in customary international law, and it was also seen in the Corfu Channel case, where Albania itself did not lay mines in the waters. However, private actors laid those mines. However, the court held them responsible because they failed to exercise due diligence. They failed to exercise due diligence, and it was quoted in the case as well. Every state has obligation not to allow its territory to be used for acts contrary to the rights of the other states. Your Excellency, that just concludes my first submission for this issue, which means that Andorivia violated the principle of non-intervention by their failure of exercising due diligence, and because the cyber attacks were orchestrated from their territory. This, along with the fact that the documents that were obtained, they contained.
How the cyber attacks were disclosed? It was hacked, it was attacked.
Your Excellency, as para 52 states that the electronic voting machines, they were attacked with virus, and the machines stopped working for some time, and when the situation was restored, then only 93% of the cast votes were recovered. So 7% of the votes were not even recovered in this case. Your Excellency, this if the court is satisfied with this, I would move to the second submission, which is that Rosenberg's interference violates Article 1.2 of UN Charter. Your Excellencies, Article 1.2 of UN Charter guarantees that all people have the right to determine their political status free from foreign intervention. Your Excellency, this was also affirmed by ICJ in Portugal versus Australia case, where they said that right of people to self-determination as evolved from the Charter and from United Nations practice has an erga omnes character and is irreplaceable. Even when the status of this principle that makes it a binding obligation that is off to every state, and it is absolutely inviolable. Your Excellency, by interfering in the internal affairs of Andorivia and launching a cyber attack, which even if they did not launch, they failed to exercise the due diligence, and they are still responsible for those attacks as they were orchestrated from their territory. Due to that, 7% of votes could not even be determined. That deprived Andorivia's population from their right of self-determination. Now, a point might be.
Cyber attack was made by the state or was some individuals?
Your Excellency, the cyber attacks, in the statement of facts it is stated that the identity of the accounts are not yet determined. However, it is uncontested fact that they were orchestrated from their territory. And as I mentioned.
What is the valid evidence of that? Is there any valid evidence that it was attack made by the said territory or from that territory?
Your Excellency, it is the facts of the case are silent whether the state themselves launched those attacks, but we are not arguing on that point. We are arguing that the attacks were orchestrated from their territory. And as per Corfu Channel case, where Albania did not lay those mines, private actors laid those mines, but the court said that every state has obligation not to allow its territory to be used for acts contrary to rights of other states, which means that as per customary international law, Rosenberg had the duty to make sure that those cyber attacks were not orchestrated from their territory, or their territory was not used to undermine the.
So they denied the fact.
Your Excellency,
they denied that they have not done this.
Your Excellency, in the facts of the case, it is written that the accounts, the identity of accounts is not clear. However, our argument is on the basis that it orchestrated from their territory, so they are responsible for it on the basis of Corfu Channel case. Your Excellency, just concluding the second submission. Now there might be a point that might be raised by respondent, or there might be a point of argument that only 7% of votes were not counted, so what difference does it make about the self-determination? Your Excellency, I would like to refer to the principle of injuria sine damnum, that if there has been an injury and their rights have been violated, even if it did not affect the election process and no damage has occurred, whether it was one person's vote, two persons' vote, the Adorivia's actions still violated their right of self-determination. And it was also...
You say only 93% votes were counted and only there was deficiency of 7% votes. So what was the actual turnout? You do not know that. Maybe the 93% was the turnout.
Your Excellency, my time's up. If I may please have 2 minutes to answer the question.
Okay.
Your Excellency, I have stated that 93% of the cast votes were recovered, 7% of the votes were not recovered, and our argument
But
is
7% votes were actually cast or not? Or the total turnout was 93 among all the voters?
Your Excellency, those votes were cast, but they were not determined that for which party they have casted those votes. And Your Excellency, it is evident that 93% is still like a major value to 7% of votes would not make a difference in the outcome of the election. However, since there has been an injury to their rights of self-determination, it doesn't matter whether it was one vote that wasn't recovered or whether it was two votes. It still violates the principle of self-determination of Adorivian people. If the Honourable Court has no further question, that concludes my submission for issue 1 and 2, and I would respectfully request that you allow my co-agent Avir for present issue 3 and 4.
Okay. Thank you very much.
The second counsel for the applicant is requested to come forward.
Number.
With the permission of the Honourable Court. Much obliged and good afternoon, Your Excellencies. My name is Abir Umar and I am the co-agent from the Council of Adorevia, in this case the applicant, and I will be presenting issue 3 and issue 4. Issue 3 is whether Adorevia violated international law when it shot down flight VA143 over a national security threat. The Council for Applicant submits that Adorevia did not violate international law when it shot down flight VA143 over a national security threat. In this regard, the issue has been divided into 3 submissions. The first one, that Adorevia's action was an act of self-defense due to instant and overwhelming threat. The second, that Rosenberg's concealment of aircraft's purpose legitimizes the act of self-defense by Adorevia. Thirdly, Rosenberg's actions endangered passengers, making it liable for their deaths. Proceeding with my first submissions, actions taken by the state of Adorevia in response to an imminent and severe security threat that was posed by flight VA143 was lawful and justified under the principles of self-defense as outlined under Article 51 of UN Charter and supported by the customary international law. Article 51 states that nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of United Nations until the Security Council has taken measures necessary to maintain international peace and security. Moreover, as highlighted in the Caroline test, which states that the necessity for preemptive self-defense must be instant, overwhelming, and leaving no choice of means and no moment for deliberation. In this case, according to paragraph 25, line 3 of the Moot compromise of the statement of facts, it states that during its scheduled journey, the flight VA143 deviated 5 nautical miles into the prohibited zone that was clearly established by the state of Adorevia. Moreover, the flight VA143's altitude fluctuated significantly. Moreover, according to paragraph 23, line 5 of the Moot compromise statement of facts, it states that the intelligence reports that were received by Adorevia's authorities revealed the possibility of hijacking due to the fact that Ziauddin, who was the leader of the terrorist organization MSRA, was in contact with the operators who were working within the state of Adorevia. Therefore, this aligned with the fact that there was a significant deviation into the prohibited zone, then the altitude that fluctuated, moreover the hijacking reports that came to state of Adorevia that
you shot the plane without any warning.
Your Excellency,
without caring that it was a civilian plane.
Your Excellency, for that I would move to my second submission.
No, you are arguing the same submissions that there was some breach of territorial limits and altitude. Then without warning, it was a good thing that you shot down the plane without any warning? What was, whether any communication was made that we should warn the pilot to go away from that outside territory?
Your Excellency, Adoravia's air traffic control tried to contact the pilots through radio calls that were made between 9:15 UTC and 9:25 UTC. However, there was no sufficient response by the pilots. Moreover, at 9:25 UTC, there were VHF calls that were made, public calls that were made by the state of Adoravia's air traffic control. However, there was still no response, and the flight
contact was established or not?
Your Excellency, the contact could not be established due to the fact that the pilot's response was insufficient, because there was no such communication that was established. Therefore, flight VA143 kept deviating into the prohibited zone.
Maybe you done it intentionally to avoid the communication so that you may have a chance to shut down it.
Your Excellency, in this case, flight VA143, since it was deviating, the state of Adoravia acted in the principles of self-defense under Article 51 of UN Charter, and the only intention was to protect themselves and their sovereignty of airspace rather than any bad faith. They acted in good faith by protecting their sovereign airspace. Moreover, proceeding with the second, if Your Excellency is satisfied with my first submission, I will proceed with the second submission, that states that Article 3 bis of the Chicago Convention states the contracting states recognize that every state must refrain from resorting to the use of weapons against civil aircraft in flight. However, it further states that this provision shall not be interpreted as modifying in any way the rights and obligations of states set forth in the Charter of the United Nations. Therefore, this directly relates to the explicit provision of self-defense that is provided under Article 51 of UN Charter, that gives the right of self-defense to the state, and in this case the state of Adoravia has acted in self-defense against the security threat due to the fact that flight VA143 deviated into their prohibited zone. Moreover, I would refer to the aerial intrusions by civil airliners and the use of force published in the Journal of Air Law and Commerce, that states that the use of force against intruding civil airliners is narrowly limited by international customary law. However, firing on such an aircraft can be considered lawful only if following three criteria are satisfied. The first criteria states that it is necessary to effect a landing for the security of the offended territorial state. This takes us to the principle of necessity, that due to the fact that flight VA143 made a significant deviation, there was a fluctuating altitude according to paragraph 34 of the agreed facts, and the fact that Ziauddin, who was the leader of the terrorist organization, was also present in the aircraft, and therefore this heightened...
How do you know that?
Your Excellency, according to the facts, if I may ask my researcher to assist with that, Ziauddin, there were reports of
I don't think that you have the list of all passengers earlier. And you are well informed to the all list of the passengers who were boarded on that.
Certainly, however, Your Honor, after the crash, due to the investigation, it did lead to the fact that Ziauddin was present in the aircraft, and the fact that there were intelligence reports.
It was just after crash when you hit 2 missiles.
Certainly, Your Excellency, however, there were intelligence reports that stated that, and these intelligence reports were credible, and they stated that Ziauddin, who was the terrorist leader, he had maintained contacts with the operatives who were within the state of Adoravia. This, along with the fact that flight made a deviation and the fact that there was fluctuating altitude, this heightened the concern for hijacking, and therefore it led to state of Adoravia to take measures of self-defense under Article 51 of UN Charter. Moreover, the fact, paragraph 23 maintains that the intelligence reports from Adoravia indicated the communications between Ziauddin and operatives within Adoravia that suggested possibility of hijacking. This, along with paragraph 35 of the agreed facts, it states that
there was no case of hijacking. Was it is the case of hijacking there? You hit the missiles. If the plane would have hijacked, then it was a different thing. You are preempting the hijacking and you hit the 2 missiles. Why? Why you have not asked him to land if there was some terrorist in the plane?
Your Excellency, in order to ask the pilots to land, first it was necessary to maintain the contact with the pilot. However, since state of Adoravia tried maintaining that contact, but there was no sufficient response from the pilot, and therefore it was necessary to maintain that contact in order to ask the plane to land safely.
That after the inquiry, the black box revealed that tried to contact the pilot, but the communication was not made.
Certainly, Your Excellency, and that is the reason why self-defense measures were to be taken, preemptive self-defense measures were to be taken due to the fact that there was no other way and no other deliberation until under Caroline test that could have asked the pilots to land due to the fact that there was no sufficient response.
And who decoded the black box? Obviously, the owner of the plane and the territory and the country. You never decoded the black box, I think, huh? Was it the case?
Your Excellency, I would ask the researcher to refer to that. Meanwhile, I would move forward.
Okay, continue. These are the questions. We are not going to confuse you. You are just asking the question. Don't worry about that. This is the habit of judges to ask questions.
Certainly, Your Excellency.
हमारे questions का time out कर दीजिए.
Don't worry about that.
Certainly, Your Excellency. Moreover, the second criteria of the report that has been submitted by the researcher, it states that importance of discontinuing the intrusion by firing upon the aircraft is in reasonable proportion to the danger to the territorial state arising from it. This relates us to the proportionality principle that according to the facts of the case, the force was justified as credible intelligence reports indicated that Ziauddin was contacting with the operators who were within the state of Arabia. And again, this along with the fluctuating altitude and the fact that the aircraft deviated significantly into the prohibited zone. Moreover, it kept deviating because there was no maintenance of contact with the pilots. This raised the concern of hijacking, and therefore it was proportional to the danger it posed. Moreover, the third criteria states that all other practicable means of discontinuing the intrusion have been exhausted. The aircraft has refused to comply with clear and appropriate instructions to return to authorized airspace. In this case as well, State of Arabia tried to maintain contact with the pilots through radio calls that were made. However, there was no sufficient response, and therefore all practicable means were exhausted by the State of Arabia, and due to the fact that there was no sufficient response, they had to...
What do you mean by sufficient response?
Your Excellency, there was no clear response by the
Is there any
pilots.
response or there is no response? If there was some sufficient response, it means that you have established the contact with them and you have get something from them,
Your
or they
Excellency,
get something from you.
certainly, Your Excellency, however, the fact states that there was no clear contact that was established, and moreover, I will refer to the facts that Your Excellency, if I may refer the researcher to indicate the facts from this.
Please continue.
If I may ask my researcher to indicate the facts, and I will answer this
Why not? Why
subsequently.
not? You can take the help of your researchers. There is no issue.
Certainly, Your Excellency. And therefore, since all the practicable means were exhausted by the State of Arabia, hence they could have resorted to the self-defense measures under Article 51 due to the fact that all the criteria of self-defense have been fulfilled by the State of Arabia. Moreover, according to Article 3C of Chicago Convention, which states that no state aircraft of a contracting state shall fly over the territory of another state or land thereon without authorization by special agreement or otherwise and in accordance with the terms thereof. According to the facts, although the flight VA143 was initially registered as a commercial aircraft, however, due to the mixed passengers such as diplomats, military personnel and police who were present in the state aircraft, it is not right to identify that aircraft as a commercial aircraft due to the fact that it was being used for state benefits, and therefore the burden of proof lies on Rosenberg that they had to seek special authorization from the State of Arabia before flying over the territory of Arabia due to the fact that it was a state aircraft under Article 3 of Chicago Convention. And this combined with the intelligence reports that of potential hijacking, it is unclear mission presented a credible and immediate security threat to Arabia. Moreover, Your Excellency, according to Article 4 of the Chicago Convention, it provides that each contracting state agrees not to use civil aviation for any purpose inconsistent with the aims of this convention. According to ICAO fact-finding investigation into the Ryanair incident, it states that in terms of preamble and Article 44 of Chicago Convention, the aims of the convention include safe and orderly development of international civil aviation and promoting the safety of flight in international air navigation. The use of civil aviation by any state for any purpose inconsistent with the aims of the convention would therefore contravene the spirit of this convention as well as Article 4. Therefore, the principle clearly establishes that using civil aviation for political or military purposes, especially when such purposes are concealed, violates the convention's objectives. Rosenberg's failure to disclose the true nature of Flight VA-143 was inconsistent with these aims of Chicago Convention, as they could not maintain safe and orderly aviation security. Therefore, this was also the violation of Article 4 of Chicago Convention, that was by the state of Rosenberg, and hence state of Rosenberg bears the burden of proof in this case. Moreover, proceeding with the third submission, that states that Article 17 of Montreal Convention provides that carrier is liable for damage sustained in the case of death or bodily injury of a passenger upon condition only that the accident which caused the death or injury took place on board the aircraft or in the course of any of the operations of embarking or disembarking. In this case, although Edorevia was the one who shot down the Rosenberg's Flight VA-143, however, Rosenberg allowed military personnel, diplomats and police to travel on that aircraft. Moreover, among these passengers was Ziauddin, who was the leader of MSRA terrorist organization, and the fact that there were reports that the possible hijacking due to the fact that Ziauddin was maintaining contact with the operators within state of Edorevia, and there was deviation and fluctuating altitude. And due to this fact, this was the direct consequence of Rosenberg's own reckless actions, including its failure to disclose critical information about the nature of its flight and its passengers, such as that of Ziauddin, who was present in the aircraft. Therefore, Edorevia had legitimate ground to act in self-defense under Article 51 of UN Charter, and therefore this is Rosenberg's responsibility to address the liability for damage in case of death or bodily injury under Article 17 of Montreal Convention. If Your Excellencies are satisfied with the submission of Issue 3, may I proceed with Issue 4?
Yes, please.
Issue 4 is whether Rosenberg violated international law by denying former Edoravian Foreign Minister Mr. Sahil Nashama immunity during protest. The applicant submits that Rosenberg did violate international law by denying immunity to Foreign Minister. In this regard, the issue is divided into two submissions. First one, that Rosenberg violated VCDR by denying immunity to Mr. Nashama, and the second one, that unlawful arrest and denial of immunity violates the UN Convention of Jurisdictional Immunity of States and their property. Proceeding with the first submission, under Article 39(2) of VCDR, it states that when the functions of a person enjoying privileges and immunities have come to an end, such privileges and immunities shall normally cease at the moment when he leaves the country, or on expiry of a reasonable period in which to do so, but shall subsist until that time, even in case of an armed conflict. In this case, Mr. Nashama was still in the territory of Rosenberg, and due to the fact that Rosenberg did not give him reasonable period of time to leave the state of Rosenberg, and that the fact that his immunity still subsists under Article 39(2) of Vienna Convention of Diplomatic Relations, since he is still in the state of Rosenberg. Therefore, his immunity has been, the detainment and his arrest is against the principle of immunity under Article 39 of VCDR. Moreover, I would like to state the case Re Regina and Pelsius. In this one, the Ontario Court of Appeal addressed a similar issue. In this case, a Nicaraguan diplomat in Canada was charged with drug trafficking and weapon offences after his functions had ended. His functions terminated on 12th July 1983, and from 16th to 23rd July, he visited United States while his family stayed back in Canada. However, in this case, the Ontario Court of Appeal established that due to the fact that he had not made a final departure from Canada, his immunity under Article 39(2) of VCDR still subsists. And therefore, in this case as well, since Mr. Nashama is still in Rosenberg, his immunity under Article 39(2) still subsists. Moreover, I would like to state the fact, paragraph 49 of Acts, if Your Excellency may refer to paragraph 49, which states that on November 5th, 2024, Mr. Nashama released a statement on social media advocating for the people of Edorevia to exercise their right to a free and fair election without any external influence. This states that when he was still a foreign minister, that is when he released the statement that he was advocating for the people of Edorevia due to the fact that their right to free and fair election were breached by the state of Rosenberg. Therefore, after he was not re-elected as the foreign minister, he was still acting in pursuance of these functions of representing the state of Edorevia. Your Excellency, may I conclude this argument in this few minutes?
Yes, why not, please?
Much obliged, Your Excellency. And therefore, when he was not re-elected as the foreign minister, he was still acting in pursuance of these functions of representing state of Edorevia and its people due to the fact that their right of free and fair election was violated. And therefore, he was still acting in his official capacity, and the fact that due to this fact, his immunity still subsists under Article 39(2) of VCDR. If Your Excellency is satisfied with my submission of issue 4, may I proceed with the prayer?
Yes.
Your Excellency, in addition to this, may I also state that Rosenberg violated UN Convention of Jurisdictional Immunity of States and Their Property. Under Article 3 of this convention, it states that this present convention is without prejudice to the privileges and immunities enjoyed by a state under international law in relation to the exercise of its functions of its diplomatic missions. This Article 3 affirms that the privileges and immunities that are recognized under VCDR and customary international law remain unaffected by any provision of this convention. And therefore, Mr. Nashama still enjoys immunity under Article 39(2) of VCDR due to the fact that Article 3 of United Convention Jurisdictional Immunities of States and Their Property does not override this convention. If Your Excellency is satisfied with the submission, may I proceed with the prayer?
Yes, please.
The counsel for applicant respectfully requests the court to adjudge and declare that the documents that were obtained from the wreckage of flight VN143 are admissible as evidence in these proceedings. Secondly, that Kingdom of Rosenberg violated international law by interfering in the election process to influence the outcome of the election in Val Sanctum region and must provide full reparation for the harm caused, including appropriate satisfaction and guarantees of non-repetition pursuant to Article 30 and Article 31 of RCEVA. Thirdly, the Republic of Edorevia did not violate international law when it shot down flight VA143 in response to a national security threat. Lastly, Kingdom of Rosenberg violated international law by denying former Edoravian Foreign Minister Mr. Sahir Nashama immunity from his actions during the protest and must provide adequate reparation, including public acknowledgement of his wrongful act and appropriate compensation in accordance with Articles 31 and 35 of RCEVA, and pass any judgment that Honourable Court deems appropriate in pursuance of equity, fairness and justice.
Thank you.
First counsel for the respondent is requested to come forward.
I would request the bench to allow me to proceed to the board.
Yes, please. Why not?
Mr. President, Your Excellency, my name is Arisha Ismail, and today I am present here along with my co-agent Ms. Mariam Fareed and of-counsel Mr. Hasan. I feel honored to stand before the International Court of Justice, and over the course of next few minutes, I'll be putting forward two submissions for the issue number 1 of our Moot problem, which states the documents obtained from flight VA143 are inadmissible before the court. The counsel for respondent would now like to proceed towards my submission 1. Your Excellency, my submission 1 is that Edorevia violated Rosenberg's rights under international law by illegally acquiring diplomatic documents. It is a well-established principle in international law that diplomatic documents must be protected and secured, which is respected and revered by states across the globe. And if we look at our current situation in the Moot problem, the documents retrieved from flight VA143 are of diplomatic nature, belonging to Rosenberg, and their seizure and their retention and subsequent use by unauthorized access amounts to a flagrant violation of the right of confidentiality of state documents. The primary treaty governing this right is the Vienna Convention on Diplomatic Relations, which protects the diplomatic immunity and protection of state documents, under Article 24 of which explicitly outlines that state archives and documents must remain inviolable regardless of their place of acquisition. And Article 27 of the same convention explicitly states that diplomatic correspondence may not be opened, seized, or used by unauthorized parties. In addition to that, the UN Convention on Jurisdictional Immunities of States and Their Property reinforces this belief that state archives and state correspondence are immune from foreign seizure and use without explicit consent. And Rosenberg, in this scenario, had not consented and was not aware of the seizure. Therefore, Adorevia's actions directly violate these principles set under international law and making its use of the documents illegal and impermissible before the court. Here I would like to rely on the landmark precedent of the International Court of Justice in Nicaragua versus US, where ICJ's ruling in this case reaffirmed that actions violating a state's sovereignty, apart from the direct intervention, which is the use of force under Article 2.4, and actions against state integrity, the indirect intervention and unauthorized use of state documents also amounts to a violation of sovereignty under international law. And applying this reasoning in the current scenario, by seizing the documents, by retaining them and their subsequent use, Adorevia not only violated the sovereignty of Rosenberg, but also intruded in its state document, which amounts to a violation of international law.
You see, there are two things. One is the violation of the treaties and the law, that they cannot open that briefcase or whatever the bag it was. But at the other end, there was some evidence disclosed against you. Then what was the evidence and what would be the admissibility of that?
Your Excellency.
Maybe that was wrongly opened, but at the same time they have got something from that.
Mr. President, thank you for the question. But when Adorevia tried to retrieve the documents, at that time it did not know whether the diplomatic bag actually belonged to Rosenberg, because due to the crash, the identification marks of the diplomatic bag had been damaged, and therefore there was no question of seizing the documents unless you were not informed whether they actually belonged to the state in question or not. I would now request the bench to allow me to resort towards my next submission.
No, maybe for the purposes of investigation they opened the bag. They did not know. You yourself said that they were not in the knowledge that there were certain confidential documents in it, and if they opened the bag and they have found something evidence in that, then
army personnel and bureaucrats of your country were traveling as a passenger in that aircraft.
Your Excellency, I appreciate your concern, but it was never clarified whether the bag actually belonged to the state in question, that is Rosenberg, and whether it had state documents inside it. So the question does not arise of investigation, and even the investigation was carried out after a delay of several days, which raises concerns about the evidence being tampered or not. I would now request the bench to allow me to proceed to the next submission, that is, illegality of evidence acquisition renders the material in question inadmissible. Your Excellency, the international law strongly adheres to the principle of ex injuria jus non oritur, which states that a right does not arise from a wrongdoing. And if we look at the actions of Adorevia here, it was in stringent violation of the international obligations, including unlawful seizure and the subsequent use of documents. And evidence obtained are in violation of legal norms. Therefore, if they are allowed to be admitted before the court, this would not deter unlawful actions in future, and it would set a dangerous precedent that would haunt the corridors of constitutionality and would set a dangerous precedent which would allow the states in future to justify their actions of violation of diplomatic state documents in cases when it is unlawful under international law. Here also,
while condemning the action, the evidence can be seen or not?
Your Excellency, thanks for the concern. The evidence cannot be seen as it is strictly prohibited under the Article 24.
We condemn the action that it was wrong. Maybe it was wrong. Perhaps it was wrong against the rules. But what they have collected from them, is it not admissible in your view?
Your Excellency, thanks for the concern. It is not admissible before the court because it was obtained through the intrusion in the sovereignty of the state of Rosenberg, as well as...
There was no intrusion.
intrusion in the privacy of the state documents.
No, it is just recovered from the wreckage of the plane.
Your
They have not recovered it from your own territory. It was there when they shot down in their own territory.
Your Excellency, it was indeed recovered from their territory, but the crash had occurred in the mid-space and therefore the documents fell in their territory. However, the documents belonged to Rosenberg and therefore they had a right of possession over it. And the acquisition and recovery by Adoravia of the state documents is unlawful under Article 24.
It was a civilian plane. They do not know that it belonged to the country or some individual. Maybe it belongs to some passenger.
Your Excellency,
You cannot distinguish that.
thanks for the concern, but it was a mistake on part of Rosenberg that they used a civilian aircraft when the passengers inside the aircraft were all the diplomats. There was also a presence of Zimin Kahara, the terrorist who was carrying out insurgencies in the region. So it was a mistake on their part that they did not use a diplomatic aircraft and resorted for a civilian aircraft. And had it been so important, they would have utilized some other source for that. Further, Article 17 and 19 of International Covenant on Civil and Political Rights 1966 also grants protection against arbitrary interference with privacy and safeguards with freedom of expression, and Adoravia's actions in retaining and examining the documents can be viewed as arbitrary intervention in the state documents. In addition to that, my argument could also be viewed from the lens of the doctrine of clean hands, which is based on the maxim of equity and states that one who comes into equity must come with clean hands. And Adoravia, in the case in question, it does not have clean hands, and thus this necessitates the requirement of court to deny equitable relief to any party whose own actions are in violation of good faith and conscience. Here I would like to refer to the case of Call-by Furniture Co-Inclusive versus Belinda J. Overton, which explains the purpose of this doctrine, that is to deny equitable relief to a party whose own actions have made it such that granting a relief would be in violation of good conscience and faith. And there was no malified intention on part of Rosenberg here. I would like to conclude my first issue by relying on the precedent of European Court of Human Rights in Judgment 60, 61 and 62 Al-Atsani versus UK, where the question before the court was whether UK's refusal to grant immunity to Kuwait in a case involving torture was justified. The court acknowledged that violations of international legal obligations cannot result in legally valid outcomes, placing it in precise alignment with the principle of ex injuria jus non oritur. Furthermore, the court in the same case emphasized that evidence which was obtained in that case through the torture of the applicant was unlawful and inadmissible before the court because torture is unlawful under Article 3 of ECHR. And applying this reasoning to the current situation, Adoravia's actions were unlawful under the stated treaties of Article 24, 27 VCDR and the UN General Resolution, and therefore their admission would not only stain our reputation and also affect our relations with others, with the neighboring states, and is also a violation of our sovereignty and confidentiality and the right of confidentiality of state documents. I would now request the bench to allow me to proceed towards my issue 2 for the same Moot problem. Thank you. My issue number 2 of the same problem is that Rosenberg's alleged interference in the election process in Val Sanctum region was not in violation of international law. My first submission for that is that Rosenberg's actions were consistent with the principle of state intervention. Secondly, the alleged electoral interference cannot be attributed to Rosenberg neither factually nor legally. For my first submission, Your Excellency, the principle of non-intervention, the basis for that to be able to fall within the ambit of the principle of non-intervention is that there must be a use of force or actions taken against state's integrity or hinder its political independence. However, in the current situation, Rosenberg's action, there was no military intervention or use of force. Rosenberg's support to a political party residing in Adoravia was merely through cultural and historical ties which it shared with the region of Adoravia, as Adoravia had priorly been a part of Rosenberg and gained independence later. And if we look at Queen of Rosenberg's statement in para 14 of the Moot problem, then it could be viewed as a symbolic announcement rather than a political endorsement of of intervention into states' internal affairs. And that was merely a symbolic one. And if we look at Mr. Mahlat, Dr. J. Mahlat, the leader of Lord's Chosen Alliance, he was an independent figure, and merely supporting or offering support to an independent figure while residing in your own state does not constitute unlawful intervention by any stretch of imagination. Moving on towards my next submission, political support is not prohibited in international law. Your Excellency, on a daily basis we come across states supporting other political parties in other states without that being deemed as unlawful or illegal intervention. If we look at United States or European Union, routinely they support democratic processes abroad without that being deemed as unlawful. Hence, Rosenberg's support
What type of support you are extending?
Support is merely morally and through political support, through cultural ties.
Financial support?
Your Excellency, thanks for the concern, but financial support was nowhere involved in the current Moot problem, and the support was merely through cultural ties and morally supporting a political party. Your Excellency, therefore, Rosenberg's actions in the current scenario fall within this permissible realm of non-coercive engagement, hence since there was no use of force or coercion. My next submission is that Rosenberg did not interfere in the election, but merely supported a movement that had grassroots population. Your Excellency, for the concern raised by my opponent learned counsel that there was a breach of right of self-determination, there was a significant, I would like to assert that there was a significant population in the region of Val Sanctum that was vouching for the Lord's Chosen Alliance because it was a religious party. And therefore, Rosenberg's support was in alignment with that segment of population, and hence no breach of right of self-determination occurred here, which has been highlighted in ICCPR, which recognizes the right of self-determination. And if a segment of Adoravia's population democratically supports Rosenberg's involvement, then there does not arise a question of Rosenberg's involvement or having reservations on that. My next submission is that the alleged electoral interference cannot be attributed to Rosenberg neither factually nor legally. Your Excellency, there was no direct evidence of state responsibility for cyber attacks. The bite blight virus mentioned in para 52 of the Moot problem, there have been indications that it was occurring from a server located in Rosenberg. However, there is no clear evidence that whether the attack was state sponsored or it was merely by a non-state actor.
But you admit it or not?
Your Excellency, the facts of the Moot problem indicate that the server were located in Rosenberg. However, we humbly deny that there is no clear evidence that this was an action that was state sponsored.
But it was done or not?
Your Excellency, according to the Moot problem, it was done. However, we humbly deny that it was done. And moving ahead towards the para 11, Dr. Mahlat was an independent former official, not acting in his official capacity anymore. He wasn't a de facto one, and therefore supporting a diplomat in another party or engaging with him. Diplomats on a daily basis engage with each other in different countries, so that can nowhere be deemed as unlawful intervention. And articles on responsibility of states for international wrongful acts, ARISWA, Article 2 of which states that for an action to be internationally wrongful, there has to be a clear attribution and proof for that state in question. And Article 8 of the same convention states that the effective control test requires that a proof must be there for a state to be held accountable that it directed or controlled actions of intervention in another state. And here I would also like to rely on the landmark cases of Bosnia versus Serbia and Nicaragua versus USA of the respected Court of International Justice, where ICJ ruled that providing ideological support and even financial support to a group in another state is not enough to attribute their actions of intervention to that state. Applying this reasoning over here, there is no evidence that Rosenberg exercised or met the criteria of effective control. And hence, Adoravia requires solid proof to prove that Rosenberg directed operations and actions that were attacking their state. In addition to that, Your Excellency, My learned opponent counsel also stated that the documents are admissible before the court because in previous precedents like Corfu Channel as well, they have been admitted before the court. However, in those cases, the question was nowhere in no precedent ever in the history of International Court of Justice has there been a case that involved a question of state documents, and hence those were rendered admissible. But in the case in question, the question revolves around this diplomatic state documents whose security is highlighted under Article 24 and 27 of VCDR. And right of self-determination is also therefore nullified because the party was supported by a significant population, and therefore the actions of Rosenberg for supporting a party were in alignment with the right of self-determination. I would like to conclude my issue 1 and 2 over here and request the court on the reasons set forth to dismiss the allegations of Adorevia and to declare that the documents obtained from flight VA-143 are inadmissible before the court, and the election interference by Rosenberg was not in violation of international law and was consistent with the principle of non-intervention. I would now request the court to allow me to invite my co-agent, Ms. Mariam Farid, to further provide her analysis on issue number 3 and 4. Thank you so much.
Thank you.
The second counsel for the respondent is requested to come forward.
Mr. President, Your Excellencies, may it please the court. I am Mariam Farid, and it's an honor to appear before the International Court of Justice, bringing the case on behalf of the respondent, Rosenberg. I'll be assisting the court on issue C and D for course of total 19 minutes, and then we respectfully reserve 2 minutes for the rebuttals. Regarding issue C, Your Excellencies, we pray before the court that Adorevia violated international law when it shot down flight VA-143 under an alleged national security threat. In that regard, I'll be making 3 broad submissions. A. Adorevia breached its obligations under the Chicago Convention. B. Adorevia's conduct undermined the principles of state responsibility. And C. Adorevia's actions failed to satisfy the conditions of necessity and proportionality under international law. With the permission of the Honourable Bench, may the Council proceed to submissions?
Yes, please.
Very grateful, Your Excellencies. Honourable Bench, at the outset, we state that the Article 3 of the Chicago Convention, it explicitly prohibits the use of weapons or use of force against a civilian aircraft in flight. And this contention has also been upheld by this International Court of Justice in the Corfu Channel case, and also constantly emphasized by the International Civil Aviation Organization that all states must prioritize the safety of a civilian aircraft and minimize the harm as much as possible. Your Excellencies, in the current case, we submit that Adorevia's actions have contravened this prohibition, as flight VA-143 posed no clear or imminent threat to its national security or integrity. The flight was merely following an international standard corridor and had not demonstrated any hostile intent. In that regard, if I may have Your Excellency's attention on case facts para 33 and 34, they state that the deviation into the ADIZ was caused by non-hostile factors like navigational errors or weather conditions, and as established by the black box evidence as stated in para 32 of the statement of agreed facts, that the aircraft's crew had attempted to respond to the calls. However, it was the navigational errors which had become a hindrance. Your Excellencies, before I further move on with my other arguments, with all due deference to the opposing counsel's claim that what are the grounds on which they are relying to perceive a certain scenario to be a threat, Your Excellencies, the main ground they have relied on is presence of Ziauddin, a known terrorist, And Your Excellencies, we humbly submit that this court has been misguided and the fact itself has been misrepresented. In that regard, if I may have Your Excellencies' attention on case facts para 23, it explicitly and unambiguously states that it was later identified that one of the persons was Ziauddin. So the point of time that we talk about...
They say that they had some intelligence report.
Thank you for the question, Your Excellencies. That is the entire contention of the state of Rosenberg, that merely relying on intelligence report and without resorting to non-lethal measures before resorting to use of force is grossly disproportionate to the speculative threat which they have posed, Your Excellencies.
They many times tried to contact the pilot, but there was no response.
Thank you for the question, Your Excellencies. The opposing counsel has upheld before the court that the response was not sufficient. However, we submit that response was indeed sufficient. In that case, if I may have Your Excellencies' attention on case facts para 26, it clearly states that the flight crew had responded by saying that adjusting and heading. Your Excellencies, that is sufficient to prove that the flight does not have any hostile intent. And in order to establish more on that, according to the civil aviation standards, the flight crew is obliged to state a code which is 7500 under a scenario if the plane has been hijacked. However, the slots of communication which happened between the both state and the flight crew, they never stated that code, and that was enough to establish that the flight is neither a threat nor is it hijacked. And Your Excellencies,
but why the plane entered into restricted territory?
Thank you for the question, Your Excellencies. As per the black box evidence, it was the navigational errors which led to deviation and weather conditions which had caused turbulence. It was never intentional on part of the state of Rosenberg, Your Excellencies. If your bench allows, may the counsel proceed. Very obliged. Your Excellencies, moving on, if for the sake of an argument, even if we consider that a threat was established, even then their conduct is unjustifiable. In that regard, Your Excellencies, the International Civil Aviation Organization's circular on the safety standards in interception of civil aircraft has laid down several protocols which every state is obliged to follow when they are perceiving a certain aircraft to be a threat. And I quote that firstly, they have to try to visually identify the aircraft or try to escort it to a safer landing. Or in other case scenarios, firstly they have to determine the nature of the deviation. And even in the worst case scenario, they can do warning shots fired at the aircraft, or they can also send fighter jets which could have intercepted the aircraft. So Your Excellencies, considering that the flight or the aircraft that we talk about, it is a civilian aircraft and a commercial flight which is undisputed as per case facts para 22, it's unambiguously stated there. So considering that the lives of 157 people, civilians, were at stake, that measure is grossly disproportionate in that regard. Your Excellencies, if I may have your attention on case facts para 32, it states that Adorevia has not exhausted all non-lethal measures. It has not resorted to the non-hostile mechanisms before resorting to military force. And Your Excellencies, we humbly submit, with all due regard for the opposing counsel's statement of the facts, the reports that they have relied on, Your Excellencies, those reports themselves undisputedly, as per para 35 of the statement of agreed facts, have suggested, and I quote, that those reports suggest that Adorevia had acted prematurely. Your Excellencies, the reports themselves are admitting that. Your Excellencies, the opposing counsels have established before the court that they had two grounds, mainly presence of Ziauddin and lack of communication. The Ziauddin presence we have already eliminated because at that point in time they were not aware of it. And considering the communication, we submit that firstly the communication which happened, it was sufficient, and even if for the sake of an argument considered that it was not, we submit that there have been no efforts on their part. And Your Excellencies, considering in the black box evidence that the transponder was working appropriately, the communication codes were being transmitted, and as per para 34, the experts have suggested that the transponder was working. So Your Excellencies,
so if the transponder was working, then why your pilot has not intimated something to them that it was wrong to enter into some restricted territory and I am going back?
Thank you for the question, Your Excellencies. As long as the transponder was working, the flight crew has responded by saying that we are adjusting and heading, which is clearly stated as per para 26 of the case facts, and that is the
It
contention.
revealed from the black box.
Yes, Your
They
Excellency.
were trying to retrieve from that territory.
Thank you for the question, Your Excellencies. Yes, they were trying to retrieve, they were trying to solve the turbulences. However, because the state of Adorabia, without giving sufficient time, without resorting to the non-lethal measures, made a hasty decision under a speculative threat which they posed, that's why we are submitting that it is grossly disproportionate. Your Excellencies, if you allow, may the Council proceed with further submissions. Very obliged. Your Excellencies, considering that the legal and factual basis for their action is not established before the Honourable Court, we also want to state that under international law there is a principle of humanity to minimize the harm to the civilian aircraft. In that regard, this International Court of Justice has ruled in armed activities on the territory of the Congo case and also in the nuclear weapons advisory opinion, and as established also in the Article 57 of additional protocols to the Geneva Conventions, that every state is mandated to take all feasible precautions to avoid or minimize incidental loss of civilian life. And considering that the state of Adorabia has not taken into account these principles, it is a gross violation of the international law. Your Excellencies, regarding the point of diplomats being in board flight VA143 as stated by the learned opposing counsel, with all due deference, we humbly submit, Your Excellencies, that increases the obligation on their part rather than decreasing. Considering the fact that the diplomats were in board flight VA143, there is also an obligation under the Vienna Convention on Diplomatic Relations that diplomats are also entitled to protection, which has also been violated in their part. Lastly, Your Excellencies, the state of Adorabia has relied on the customary right to self-defense under United Nations Charter. However, we submit that that charter itself has two very important limbs, which are necessity and proportionality. And the state of Rosenberg submits that both of those limbs or both of those components have not been satisfied in the current case. Your Excellencies, as established in the Caroline incident, which was also stated by the opposing counsels, it clearly establishes three conditions, but one main condition have been missed out by the opposing counsels. It states that there should be a clear threat, it should be an imminent threat, and all non-lethal measures must have been exhausted. Your Excellencies, regarding the first two parts, clear and imminent threat, the grounds on which they have relied, they are not legitimate, which we have already discussed before the Honourable Court.
What do you say about proportionality? What is the proportionality issue in this case?
Very obliged, Your Excellencies. The proportionality principle has to be complied as per the international law.
What sort of?
Very obliged, Your Excellencies. Considering that 150 civilians along with the military personnel were in board flight VA143, therefore any action which they had to take, they had to keep in mind whether is it proportional to the threat they are posing, and considering, Your Excellencies, the main rationale of this argument or this contention is that it would have been justified considered they had made all the efforts. Then
when you argue the proportionality doctrine of proportionality, then you have to explain that what measures they should have been taken first without before shooting.
Indeed, Your Excellencies.
Yes. So what are the proportionality measures which they failed to take before hitting the missiles?
Indeed, Your Excellencies. As ruled in the legality of the threat or use of nuclear weapons in 1996 by this International Court of Justice, it has ruled down several components which they have to comply in order for proportionality, and in the current case, two of them apply, Your Excellencies. The first one is that as a precautionary measure, they have to send fighter jets which have to intercept the aircraft, and secondly, regarding the use of force, they can only do warning shots can be fired on the aircraft, Your Excellencies. If your Honourable Court has no further questions regarding issue C, may the Council proceed to issue number D.
Yes, please.
Very obliged, Your Excellencies. Your Excellencies, regarding issue D, we pray before the court that Rosenberg did not violate international law by denying immunity to Mr. Sahir Nishama. In that regard, I'll be making 3 submissions. A. Your Excellencies, state officials or former state officials are not entitled to immunity for the acts which are not in their official capacity. B. Immunity does not provide a blanket protection. And C. Every state has a right to take action to maintain the law and order inside its territory. With the permission of the Honourable Bench, may the Council proceed to submissions. Much obliged. Your Excellencies, first and foremost, we state that diplomatic immunity or immunity ratione matirae is not applicable for the acts which are not in the official capacity of a person. And this principle, which is a very well-known principle of public international law, has been upheld by this International Court of Justice in the cases of Democratic Republic of the Congo and Belgium, and also in the landmark case of Disputi versus France. The court ruled, and I quote, that immunity does not extend to private acts which are unrelated to official duties. Your Excellencies, in that regard, if I may have your attention on case facts para 49, it states that Mr. Nishama's actions during the protest, which include making demonstrations or making public statements, were not in their capacity as a foreign minister, but rather a civilian who was participating in the political activism. And Your Excellencies, regardless, the acts for which they have been detained, mainly, they have occurred after they have ceased to be in the office. In that regard, it is clearly and unambiguously stated in the para 57 and 59 of the case facts, and thereby we state that Mr. Nishama was no longer serving as the foreign minister of Adorabia. Therefore, the point in time when they are not a state official, they are a civilian, and the actions they commit, they will not be considered the ones which are entitled to immunity ratione personae or even immunity ratione materae. Your Excellencies, establishing more in that argument, the concept of immunity, with all due deference to the opposing counsel, they have established the concept of immunity in a very rigid or absolute manner. However, the respondent, Rosenberg, submits that immunity does not provide a blanket protection, considering that all the states have a margin of appreciation. And Your Excellencies, considering that Mr. Nishama, as a civilian, after ceasing to be in the office, throughout para 49 till para 59, we have seen that they have been scrambling the public order of the state of Rosenberg. They have
what
been.
he was doing actually?
Thank you for the question. In para 49, there is a series of events. May the council state all the actions that have been committed by them, which has impacted the national security.
You can say 2 or 3 acts.
Thank you for the question.
Without reading that paragraph.
Indeed, Your Excellencies, they had started to do public demonstration. They had to started to incite violence among the protesters, and lastly, they had made public statements which led people to increase the protest. So, since Mr. Nishama was the one heading all of these things, hence they are the prime person who has become a reason for scrambling or disrupting the law and order situation inside the state of Rosenberg.
If he does not claim any immunity, even then he can't do this. If he does not claim any immunity, but as a person, as a civilian, he can't do this.
Thank you for the question. Under the National Stability Act, Section 12 of the state of Rosenberg, every person has to comply with the laws and regulation, and they must not involve into actions which are disrupting the public order of the state.
Was he not exercising his right to speech and expression?
Thank you for the question, Your Excellencies. The right to expression is not an absolute right, Your Excellencies. And even in every constitution, the right to expression or speech comes with certain exceptions. So dignity of a person or security of a state must be taken into regard. Your Excellencies, we cannot consider this right to give a carte blanche to any person to do anything they want. That would merely set a very dangerous precedent, as there would be no limit on the actions, Your Excellencies. May the Council proceed. Very obliged. Your Excellencies, to continue with that, and as established by this International Court of Justice in the case of Nicaragua versus United States, and also in the case of Guinea versus Democratic Republic of the Congo, that every state has an obligation and perhaps a right to preserve the public stability and safeguard the welfare of its citizens. And this principle or this contention has also been established by the Article 2, subsection 7 of the United Nations Charter. Your Excellencies, regarding the second last submission on this issue, with all due regard for the opposing counsel, they have merely relied on Article 39 of the Vienna Convention of Diplomatic Relations. However, we humbly submit that we cannot see that article into isolation. If we look at Article 39 of the VCDR in conjunction with Article 41 of the same convention, it states, and I quote, that it is the duty of all persons enjoying such privileges and immunities to respect the laws and regulations of the receiving state. Your Excellencies, considering that Mr. Nashama's actions have constantly violated the National Stability Act and scrambled the public order, hence this provision, if looked in isolation, cannot be applicable on them. Your Excellencies, this was also upheld by the opposing counsels that the state of Rosenberg could have resorted to other measures, but in that regard, Your Excellencies, the whole rationale, the whole logic behind this is. Your Excellencies, my time is up. If I may have a while to conclude my arguments.
Yes.
Very grateful. So, Your Excellencies, we submit that we have taken confinement as a temporary and as a precautionary measure. So, we cannot compare it to the acts which are not in official capacity, and we have not disregarded the immunity in totality. However, it has been done, the confinement, the act itself has been done for a lawful purpose. And since the international law is also granting permission under such circumstances, therefore, Rosenberg has not indeed violated international law when it disregarded immunity of Mr. Zahir Nishama. That brings us to the end of submissions regarding issues C and D. If Your Excellencies have no further questions, may the Council proceed to prayers.
Please.
Very obliged.
Read the prayer.
Very obliged. Your Excellencies, the State of Rosenberg requests the court to adjudge and declare that the documents illegally obtained in the wreckage of flight VA143 are inadmissible as evidence in these proceedings. B. Rosenberg's alleged interference in the election process in Val Sanctum region was not in violation of international law. C. Admissibility violated international law when it shot down flight VA143 under an alleged national security threat. And lastly, we pray before the court that Rosenberg did not violate international law by denying former Admissibility Foreign Minister Mr. Zahir Nishama immunity from his actions during the protest. Thank you, Your Excellencies.
Thank you.
If the Honourable Court has no further question, the Council would like to leave the
Time
floor.
is over.
Very obliged. It was
Thank
an
you.
honor to plead before the International Court of Justice.
Thank you.
Applicants are requested to present their rebuttals.
Both will address the rebuttal or one person? You and your colleague? Only one. How much time is granted for rebuttal?
Your Excellency, 3 minutes.
Okay. Please continue.
Your Excellency, the learned counsel for respondent has raised some interesting arguments. Firstly, they have mentioned UN Convention of jurisdictional immunities for states and property. However, this convention is not applicable as Article 2 of the convention, it defines court as any organ of state, however named, entitled to exercise judicial functions. The documents retained were not admitted to any court in Adorivia. They were protected under national defense secrets and are presented in ICJ, and ICJ is not an organ of a state. Then they mentioned the principle of ex injuria non oritur and clean hands, meaning that right does not arise from a wrong. However, the documents have the evidence of direct interference in the internal affairs of Adorivia. They also mentioned the good faith principle. Your Excellency, we contend that their own actions were not in good faith when they interfered in our internal affairs. They did not have clean hands themselves. So their reliance on these principles is quite ironic. Secondly, we did not argue about military or financial support or any statement of the Queen. Their argument in this regard are irrelevant to the proceedings. We only relied on cyber attacks that were orchestrated from Rosenberg territory, for which Rosenberg failed to exercise due diligence. It constitutes a violation of international law. They also mentioned that it could not be attributed towards the state just because it was orchestrated from their territory. However, as established in Corfu Channel case, the Albania was held liable even for the acts of private actors because they failed to exercise due diligence. Your Excellency, it was irrelevant who was supporting which party. Adurivia's people's vote were not recovered. It does not matter who won or if one or two votes were not counted. It remains violation of right of self-determination. As I have already mentioned in my submission, the principle of injuria sine damnum, even if there is no damage, there has been an injury and violation of rights of people of Adurivia. Your Excellency, the issue revolves around admissibility of illegally obtained evidence and not if the states not if the evidence contains state documents or not. Corfu Channel case was about admitting illegally obtained documents regardless of whether it was state documents or not. Your Excellency, they also mentioned that there was no coercion. However, as per the Tallinn Manual on Cyber Attacks, it states, for an act to amount to coercion, it must effectively deprive target states of control over matters in its sovereign prerogatives through pressures that cannot be reasonably resisted, which means that the cyber attacks could not be reasonably resisted by us, and that was our own sovereign prerogative that has been violated. Furthermore, the respondent raised that the under Article 3 the states should refrain from use of weapons. However, Article 3 states that provision of refraining to resort to, Your Excellency, may I please have the moment?
Yes.
To resort to use of weapons shall not be interpreted as modifying in any way the rights and obligations of states set forth in UN Charter, which relates to the Article 51 of UN Charter to use measures of self-defense. Furthermore, in order for visual identification or for asking the plane to land, it is important for the communication to be established, which with the pilots, which was not possible in this case. If communication could have been established, could not have been established. It was Rosenberg's duty to inform the state of Adurivia the nature of deviation, but Rosenberg was silent in this regard. Furthermore, Adurivia did in fact issued a warning through open VHF channels, but the pilots did not acknowledge, as mentioned in para 28 of the Moot compromise. As per the issue 4 about the immunity, Your Excellency, we contend that immunity for Mr. Nishama was absolute immunity. We rely on immunity rationae personae. He is immune for both official and private acts by virtue of his office. So it doesn't matter.
They said that he was not in office.
Your Excellency,
how you can claim the immunity when the person has already left the office? Then how the immunity can be claimed under the international law?
Certainly, Your Excellency, for that we are relying on Article 39(2), which has been discussed by my co-agent. It states that even when his term ended and he ceased to be in the office, the absolute immunity for both official and private acts official and private acts shall subsist until he leaves the country. In this case, while he was not re-elected, he had not left the state of Rosenberg yet, and they detained him, denying him his immunity. Other than that, they raised concern about the incitement of violence and that they applied their National Stability Act. In that regard, even if Rosenberg was concerned with his actions and they considered that he was interfering in the internal affairs as per Article 41, even if he was concerned with the actions and considered them to be threat to national security, VCDR provides remedies for that. They do not have to rely on their National Stability Act. As per Article 9, they could have declared him persona non grata, an unwelcome person, or as per Article 32, they could have requested Adurivia to waive his immunity. They did not exercise these measures, and they directly detained him under their own National Stability Act. Your Excellency, we contend that VCDR is a self-contained regime. It has remedies for all the violations committed by the diplomats, and the National Stability Act that they are relying on, VCDR has a customary value and it overrides the National Stability Act. Your Excellency, that's all for rebuttals. However, the question that was asked from my co-agent, if I could answer that in just 1 minute.
Yes, please.
Your Excellency, the Honourable Court asked about insufficient response from pilots from my co-agent. Under para 26 line 3, it states that pilots' responses consisted of unclear statements, such as adjusting heading without elaboration of cause of deviation, combined with Rosenberg's delayed responses to air traffic injuries, reinforce the heightened concerns of potential hijacking.
Thank you.
Much obliged.
That's all. Thank you. Is there any sir rejoinder?
Respondents are requested to present their rebuttals.
Your Excellencies, we have 6 rebuttals. With the permission of this honorable bench, may the council begin. Very obliged. Your Excellencies, first and foremost, the opposing counsel has stated Article 3 of the Chicago Convention. However, the subsection which they stated, it also states, and I quote, that the contracting state recognizes that every state in the exercise of its sovereignty is entitled to require the landing at some designated airport of a civilian aircraft flying above its territory without authority, or, Your Excellencies, it states that if there are reasonable grounds to conclude that it is being used for any purpose inconsistent with the aims of that convention, and even if in that situation, it may also give such aircraft any other instructions to put an end to such violations. Your Excellencies, as established before the Honorable Court during our pleadings, that since those reasonable grounds have not been set, therefore the Article 3 is not even applicable in these circumstances. Secondly, Your Excellencies, the opposing counsel had stated certain instances of where the flights had been shot down, and they have justified their arguments through that. However, we humbly submit that those instances are inapplicable, considering that both the flights that they mentioned, they were state properties, Your Excellencies. So considering that the flight in consideration, it is a commercial flight, it's a private property, so the level of the protocols, it differs, it becomes very different. So we cannot consider or compare an instance of a state property with that of a civilian aircraft. Your Excellencies, regarding the right to self-defense under United Nations Charter, firstly, before going to the merits of the actions, the article itself is inapplicable, because the right to self-defense through the United Nations Charter is in the context of state property. And as we have considered and established before the court that the flight under consideration was a private property, hence this right cannot be exercised. Your
Want to say
Excellency?
something more?
Yes, Your Excellency,
Please
3
continue.
more rebuttals. Next, with all due deference to the opposing counsel's understanding of the immunity law, Your Excellencies, we humbly submit that it is without objection and it's a settled principle of international law that the only immunity which extends to the former state of officials is immunity rationale materiae for acts which are in their official capacity. Since they were not serving as a state official, that's excluded. They have also contended that
They say
immunity...
that it can be extended for certain period, unless he leaves the territory.
Thank you for the question. Your Excellencies, we humbly disagree. It cannot be extended. Immunity rationale materiae can
But
only be...
They are relying on some rule. They are relying on some convention.
Your Excellencies, very obliged, as we have stated, the landmark case of the Democratic Republic of Congo versus Belgium and also Djibouti versus France, in that the International Court of Justice has explicitly stated that immunity personae or immunity personae and immunity rationale materiae have different standards. So regarding the rationale materiae part extended on their behalf was that we submit that because the rationale behind that immunity is the person itself. So considering that the person has ceased to be in the office, the immunity won't apply, Your Excellencies. Besides that, they stated that the state of Rosenberg could have resorted to other measures like considering the waiver of immunity or considering the person non grata under Article 9 of the VCTR. However, Your Excellencies, considering the same Article 9 of the Vienna Convention on Diplomatic Relations, that is the entire contention of the respondents before the Honorable Court, that in order to record the evidences, in order to comply with all the precautionary measures, confinement had to be done as a temporary measure in that regard, Your Excellencies. And lastly, Your Excellencies, they have considered and perhaps emphasized on the point of military personnel or the plane being a state property. So we submit that it's a norm that diplomats, military personnel, they do use commercial flights for travel. But the rationale or the logic here is that the military personnel traveling in a commercial flight, it does not change the standard of the protocols which the state of Saudi Arabia is obliged to follow. Therefore, Your Excellencies, in light of the rebuttals advanced, we submit that Rosenberg has not violated the international law.
Anything else?
No, Your Excellencies, we are done.
Thank you.
Very obliged. It was an honor to plead before the International Court of Justice.
The Honourable International Court of Justice has now adjourned. All the participants and the spectators, please remain within the courtroom while the judges may go to deliberate. All rise.
Justice is not a distant star, nor locked behind an iron bar. It lives within the words we speak, the laws we shape, and the truth we speak. Good afternoon, esteemed justices, distinguished participants, and guests. I am Ashna Yasin, the president of Denning Mooting Society, and it is both an honor and a privilege to welcome you all to the closing ceremony of the 3rd Denning National Moot Court Competition 2025. Over the past few days, we have witnessed remarkable advocacy, unwavering determination, and the highest standards of legal argumentation. Today, we gather here just not to celebrate the victors, but to acknowledge the collective effort that has made this competition a grand success. Please, everybody, let's put a huge round of applause for this. To begin this ceremony in the most blessed manner, I now invite Ahmed Berni to come forward for the recitation of a few verses from the Holy Quran.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم إنا أعطيناك الكوثر فصل لربك وانحر إن شانئك هو الأبتر صدق الله العظيم.
Jazakallah. Thank you for the beautiful recitation. Before we proceed, I request everyone to please rise for the national anthem as we pay tribute to our country and its values.
you, everyone. Please be seated. It is an extraordinary privilege to have in our presence two eminent figures of the judiciary, the Honourable Mr. Justice Muhammad Ali Mazhar and Honourable Mr. Justice Hasan Azhar Rizvi. Their presence here today not only enhances the prestige of this event, but also serves as an inspiration to all aspiring legal minds gathered here today. Their dedication to upholding justice and their vast contributions to the legal system set an example for all of us here today. We are deeply grateful for their time, wisdom, and invaluable contributions to the legal landscape. Let's give them a warm round of applause. I would also like to extend a warm welcome to the distinguished Bar Council members who have joined us today as our esteemed guests of honors. Your support, commitment to the growth of the legal advocates play a crucial role in shaping the future law and justice. Your dedication to fairness, integrity, and mentorship has been instrumental in guiding the next generation of legal professionals. We are truly honored by your presence here today. Please give them a huge round of applause. Now, I would like to invite Honorable Justice Mr. Muhammad Ali Mazhar as our chief guest to the stage to share his thoughts with us. His vast legal acumen, unwavering commitment to justice, and immense contributions to the legal system make him a guiding light for all of us. Please welcome him on stage with a huge round of applause.
Bismillahirrahmanirrahim. Honorable faculty, distinguished guests, respected judges and aspiring advocates, and most importantly, the senior advocates present in this program. It is a privilege to address such a talented gathering of future lawyers at the third Danning National Moot Court competition. While I regret that I could not witness all the arguments presented today, but I have no doubts that the advocacy skills on the display were remarkable. Moot court competitions are more than just academic exercises. They are invaluable training grounds for the legal profession. Every seasoned lawyer and judge will tell you that the law is not learned merely from books, but through practice, observation, and experience. Mooting allows you to bridge that gap, and it transforms legal principles from abstract concepts into real-world applications. The value of moot courts extend far beyond winning or losing. They teach you how to construct a persuasive argument, think on your feet, and present your case with clarity and confidence. These skills are not just useful in the moot courts, they are very foundation of the successful legal career. As a judge, I can assure you that the ability to be articulate, concise, and well prepared in court is one of the greatest assets a lawyer can have. But beyond technical skills, mooting inspires something even more crucial, the essence of justice. A lawyer's duty is not merely to argue, but to unfold fairness, to seek the truth, and to ensure that the law serves the people it was meant to protect. The great philosopher Socrates once said, "The only true wisdom is knowing that you know nothing." The legal profession requires constant learning of different laws and the case laws, firm preparation of cases, and its presentation in the courts with proper decorum. The experience of mooting is also a glimpse into the reality of legal practice. The pressure, the unpredictability, the need to think critically under scrutiny. All of these mirror what happens in the real courtrooms. But unlike a real courtroom, there is a space where you can make mistakes and learn from them, where you can refine your legal acumen without the real world consequences of an adverse judgment. One of the most valuable lessons you will take from this competition is that advocacy is not just about speaking well. It is about listening, analyzing, and responding with precision. A lawyer must not only have the ability to present a compelling argument, but also the humility to acknowledge counter-arguments and refine their stand accordingly. This intellectual agility is what distinguishes a good lawyer from a great one. I would like also to remind you that the legal profession is not just about competition. It is about service. While many enter the law with the dreams of success and prestige, the true measures of a lawyer is not in the cases they win, but in the justice they uphold. It is easy to advocate for those who can afford your services. The real test lies in advocating for those who cannot afford the higher fee of the advocates. As you move forward in your careers, I urge you to hold on to the spirit of curiosity, discipline, and integrity that has brought here you today. Maintain the habit of thorough research, develop a keen understanding of legal principles, and most importantly, never lose sight of the ethical responsibilities that come with this profession. I congratulate all the participants for their hard work and commend their organizers for providing this invaluable opportunity for young legal minds. Whether you leave this competition with trophy or not, you have already won by immersing yourself in an experience that will shape your journey in the legal world. Today we have experienced the arguments of both the applicant and the respondent, and it is really very good, and both teams were well prepared and they tried their level best to articulate their arguments. But in the real world also, whenever you will enter into the legal profession, one will lose and one will win. This is not the time, and this is not the matter of any frustration for you as a good advocate, because you tried your level best, and if you will have the good case, you will get the success. And obviously in your legal profession also, you will have to face daily competition. This is the moot where you can win, you can lose, but the party is not affected. You will not affect anyone if you will lose the case. But in your real profession, whenever you will go, it is my humble advice as a judge of the Supreme Court to all the new advocates who are sitting here and they are planning to enter into this profession, that you work hard will give you a good success, and don't waste your time in bar rooms whenever you will enter into the legal profession after taking the license from the bar for starting your practice in the lower courts. Obviously you will not directly enroll in the high court. You have to be enrolled for your local bar council, and when you will enroll, try to work hard, research work, legal acumen, read the laws. In this University of London case, I always remind the organizers also that they know only the foreign laws, international laws, but they don't have the legal laws knowledge. So when you will enter practically in your profession, you have to go through the laws of our own country. Maybe it may be the family laws, it may be the rent laws, it is Civil Procedure Code, Pakistan Penal Code, Criminal Procedure Code, Contract Act, Special Relief Act, Transfer of Property Act, Sales of Good Act. There are so many laws. When you will start practice in this country, in any province of this country, you will have to know the laws where it is already in field and in vogue. The English laws will not support you, but the law will support which we are already dealing with, and we are facing the cases, and the cases are being instituted in that laws. Anyway, this was not out of the context, but both the teams were very well, and they were well trained, and we were asking the questions not to confuse you. Don't think that there was any such element of or any such trick of confusing the young legal minds who are entering into the profession, but the judges are in habit to ask the question, and we were just asking the question because we wanted to see that how much you are well prepared and whether you are really well prepared or not. So this was not meant to distract you, but just want to know, okay, what preparation you have made, whether you are able to answer a spontaneous question to the judges or not, because when you will go in field, the judge will not ask you that please be prepared, I am going to ask this question to you. Randomly questions are being asked, even in the High Court, in the Supreme Court. It is now your preparation which depends the answer of this question. If you will not prepare properly, you will be confused. I try to confuse you sometimes, but it was not the intention to distract you. I just wanted to know what legal acumen you have, at least in this case, what type of preparation you have made at least to answer in this case. So both parties have responded well, but this is the law that one wins and one loses, so we have no control even in our own judgments. One party wins and one loses, so this is the life which you have to be there. Anyway, the road is ahead is long, challenging, and often certain. Keep striving, keep learning, and keep advocating, not just for your client, but for Justice Esther. Thank you very much.
Thank you so much. We appreciate the insightful words from the Honourable Mr. Justice. Next, it is my honor to invite Honourable Mr. Justice Hasan Azhar Rizvi, our special guest of honor, to stage to address us. His commitment to upholding the rule of law and his dedication to nurturing legal minds have made a lasting impact on the community. Sir, we are eager to hear your insights.
Bismillahirrahmanirrahim. Mr. Justice Muhammad Ali Mazhar Sahab, respected faculty members, competitors of 3rd Denning National Moot Court competition, members of Sindh Bar Council, lawyers, students of Denning, ladies and gentlemen, Assalamu alaikum. Competition like this are not just about winning or losing. They are about growth, learning, and the pursuit of excellence. Each one of you has demonstrated remarkable skill, dedication, and perseverance, proving that the future of the legal profession is in capable hands. I extend my heartiest congratulations to the organizers of the 3rd Denning National Moot Court competition for creating this platform where aspiring legal minds can challenge themselves and refine their advocacy skills. Being part of this event as a judge has been an absolute privilege, and I am truly impressed by the talent and passion displayed here today. Legal education is not just about memorizing laws. It is about developing the ability to think critically, argue persuasively, and stand firm in the face of
challenges. Moot court competitions serve as a training ground where law students transforms into confident advocates. The way you have all presented your arguments, responded to questions, and defended your positions shows that you are well on your way to becoming exceptional legal professionals. However, true success is not measured by trophies or certificates. It is measured by how much you learn, how you apply that knowledge, and how you continue to grow. Every round of debate, every challenge faced, and every lesson learned here will contribute to your future success. Congratulations to all the participants for their hard work and dedication. The legal world await your contributions, and I have no doubt that you will leave a lasting impact. As you move forward, remember this: the true test of leadership is not how you perform when everything goes right, but how you rise when faced with challenges. Thank you.
Thank you, Honourable Mr. Justice, for your insightful words and invaluable wisdom. Every great endeavor has a backbone, a pillar of strength that keeps things together. For this competition, that pillar has been my Vice President, Mr. Musharraf Sarhandi. His unwavering support and commitment have been indispensable, and I am honored to invite him on the stage to share a few words. Please welcome him with a big round of applause.
Honorable Justices of the Supreme Court, esteemed guests and distinguished participants and fellow students. Good afternoon and Assalamu alaikum. As the Vice President of the Mooting Society, it is both an honor and a privilege to address you the closing of the third National Moot Court competition. Over the past 3 days, we have witnessed an outstanding display of legal expertise, commitment and passion from all those involved. I express my deepest gratitude to the Honorable Justices of the Supreme Court, Honorable Mr. Justice Muhammad Ali Mazhar and Honorable Mr. Justice Hasan Azhar Rizvi, who have graced us with their presence by taking out time for the students. Your thoughtful analysis and constructive feedback have greatly enhanced this competition during the finals. I'm also grateful to the senior lawyers of the legal fraternity, consisting of the esteemed members of the Bar Council, to be with us today as guests of honor. This competition could not have been possible without the Danning Mooting Society. The Danning Mooting Society is a student-run body guided by our patron, Mr. Zaman Khan. This society has worked tirelessly for 3 to 4 months to execute this event. The credit is due to our talented team consisting of the executive body, the organizing committee members, as well as the team volunteers. We are thankful to our president, Ms. Ashna Yasin, for her directions and patron to be the guiding light for us. Lastly, dear participants, it was an honor to host you at the third Danning National Moot Court competition. Your tireless preparation, remarkable legal arguments, and dedication to the excellence have truly set a high standard. It has been a privilege to witness your growth, and we look forward to seeing your future achievements in the legal profession. Thank you.
Thank you for your words and unwavering support, Musharraf. It is now my pleasure to invite our esteemed patron, Mr. Mohammad Zaman Khan, to share a few words of wisdom with us. His guidance, leadership, dedication to the legal field have truly been inspiring. Sir, we are truly grateful for your unwavering support. I'd like to welcome him on stage with a huge round of applause.
Thank you, Ashna, for the kind introduction. Honourable Mr. Justice Muhammad Ali Mazhar, Honourable Mr. Justice Hasan Azhar Rizvi, esteemed members of the judiciary and legal fraternity, distinguished guests, faculty members, and most importantly, our exceptional mooters. It is both an honor and a privilege to stand before you today as we bring the third Denning National Moot Court competition to a close. Over the past few days, we have witnessed an extraordinary display of legal intellect, persuasive advocacy, and unwavering passion for the law. Mooting is not merely an academic exercise. It is a rigorous test of intellect, composure, and the ability to articulate justice with precision and persuasion. And each one of you, through your arguments, commitment, and your dedication, has exemplified these very aspects and qualities. We were privileged to have the final of this prestigious competition adjudicated by none other than Honourable Mr. Justice Muhammad Ali Mazhar and Honourable Mr. Justice Hasan Azhar Rizvi, two towering figures of our judiciary whose presence today not only elevates the status and the stature of this competition, but also serves as a beacon of inspiration for our young advocates. Your Lordships, we are deeply grateful for your time, your wisdom, and invaluable insights that have undoubtedly enriched the experience for our finalists and for all of us in attendance. To all our participating teams who have traveled from all across the country, you brought with you the brilliance of your advocacy, and in doing so, you illuminated Karachi, the city of lights, with your intellect, eloquence, and quality. It is your dedication that makes mooting such a powerful tool for shaping the lawyers of tomorrow. Whether you walk away with the trophy or not, know that your experience gained here, the friendships you have built, and the lessons you have learned will serve you for a lifetime. You have made this competition an event which you will cherish for your lifetime, an event that you will remember, and for that I extend my deepest gratitude to all of you. Yet, no event of this magnitude is possible without the hands that work tirelessly behind the scenes. The Denning Mooting Society stands at the heart of this competition, and today I must acknowledge the sheer dedication and passion of the individuals who have made these possible. To our President, Ms. Ashna Yasin, your leadership has been the driving force behind the seamless execution of this competition. Your unwavering commitment to the growth of the Mooting Society at Denning is commendable. To our Vice President, Mr. Musharraf, the Chief Operating Officer, Mr. Jawad, and the Chief Communications Officer, Ms. Hanana, you have held the pillars of this competition together, ensuring that every logistical detail was meticulously managed. To our lovely senior academic curators and junior academic curators, your diligence in preparing the exceptional moot problem and ensuring the highest academic standards has set the precedent for excellence. To organizing committee members, courtroom officers, file room volunteers, and all other volunteers, your hard work and dedication has been the backbone of this competition. Your tireless efforts, from ensuring courtrooms ran smoothly to handling the endless logistics, especially my lovely deputy logistics, Mr. Samir, Mr. Ahmed Barni, and Ms. Haika. But beyond the efforts of our Mooting Society, there is an institution that stands unwavering in its commitment to legal education and advocacy. Denning Law School, under the leadership of Mr. Husaifa Muqaddam and Mr. Abdul Qadir Naeem, continues to foster an environment where legal excellence thrives. Their vision, mentorship, and support have been instrumental in ensuring that mooting at Denning does not just exist, but flourishes. Thank you both for your guidance, trust, and constant encouragement. Equally vital to this competition's success are those who work tirelessly behind the scenes, often unseen, yet indispensable. I extend my sincerest gratitude to our administrative staff, especially Sir Fayaz, Sir Mohib, for ensuring that everything ran smoothly from the venue arrangements to the operational logistics. Their dedication is truly commendable, and the event would not be possible without them. As we conclude this remarkable journey, I leave you all with a final thought. Mooting is just not about advocacy. It is about resilience, adaptability, and the courage to defend what you stand for and is right. The lessons you learn from this competition will go far from these courtrooms and beyond these courtrooms. They will shape your careers, your principles, and the very pursuit of justice you strive for. To whoever wins, congratulations on a well-earned victory. To whoever is the runners-up, your performance was nothing short of outstanding. And to every participant, know that you will leave this competition not just as better advocates, but as valuable members of the future legal fraternity itself, who will one day stand before real benches, in real courtrooms, fighting real cases, and shaping the future of law and justice in Pakistan. With that, I officially declare the 3rd Denning National Moot Court Competition closed for debate. Thank you all, and may your journeys in law advocacy continue to be marked with brilliance and success. Thank you.
Thank you for your inspiring words and steadfast guidance, Sir Zaman. It is my pleasure to introduce our Director of Academics, Sir Huzaifa Muqaddam. His dedication to legal education and his unwavering support for mooting initiatives have been invaluable to this institution. We are honored to have him share his thoughts with us today. Sir, please join us on stage with a huge round of applause.
Honourable Mr. Justice Muhammad Ali Mazhar Saab, Honourable Mr. Justice Syed Hasan Azhar Rizvi Saab, the Justices of the Honourable Supreme Court of Pakistan, my seniors from the legal fraternity, members of the Pakistan Bar Council, members of the Sindh Bar Council, I would like to extend my salam and the greetings. Assalamu alaikum and good evening. I would like to extend my deepest gratitude to the esteemed final judges for their invaluable time and insight in evaluating the finalists today. Your presence has elevated this competition and provided our participants with an experience that will leave a lasting impact on their legal careers. A special thanks to our semi-final judges who took out time from on the challenging task of selecting today's finalists. Their rigorous assessment and keen observations played a crucial role in shaping the outcome of the competition. To our distinguished guests from the legal fraternity, your experiences and contribution to the profession inspire our students to push beyond academic boundaries and into the real world of legal practice. Your support of mooting and legal education is what enables institutions like ours to provide such platform for aspiring advocates. To the participants, your dedication and hard work have not gone unnoticed. Mooting is not just about courtroom victories. It is about learning to think critically, argue persuasively, and uphold the principles of justice. Whether you take home the trophy or not, you leave this competition stronger, more confident, and better prepared for the legal world ahead. I would also like to take this opportunity to just reiterate the duty of a lawyer or a duty of an advocate. The first and the primary duty of an advocate is towards the court and in order to assist the court in administration of justice. That is the first and the primary duty of an advocate. Secondly, the duty of an advocate is towards their client. Thirdly, is their duty towards their fellow advocates. And lastly, they also owe a duty towards the larger community in ensuring upholding the rule of law. So these are some of the duties which a lawyer should always remember throughout their career. I would also like to recognize the Denning Mooting Society and the organizing team whose tireless efforts behind the scenes made this event possible. A special thanks to Mr. Zaman Khan. A huge round of applause goes to him for your unwavering commitment to excellence. As we close this competition, I hope each of you carries forward the lessons learned here, not just the technicalities of legal argumentation, but the resilience, teamwork, and intellectual curiosity that define great advocates. Congratulations to the winners, commendations to every participant, and a heartfelt thanks to all those who contributed to making this competition a real success. We look forward to welcoming you all again next year with even greater passion and commitment to law. Thank you.
Thank you for your insightful words and unwavering dedication to legal education, Sir Josefa. A competition of this caliber is not just about the winners, but about the journey every participant has embarked upon. Each of you displayed resilience, intellect, and commitment to excellence. Let's give a huge round of applause for all our participants. We now move on to the much-awaited award ceremony. I invite our special guest of honor, Honourable Mr. Justice Syed Hasan Azhar Rizvi, to join us on stage to present the awards. The first award is Best Memorial Applicants, Team DNMCC 05. Thank you. Congratulations. The next award is Best Memorial Respondents, Team DNMCC 11. Huge round of applause, everybody. The next award is the Best Speaker of the qualifying rounds, and this award goes to Ali Raza from DNMCC 06. This award is being awarded to Sindh Mehran Institution. Congratulations. The next award is the Best Emerging Team, and the Best Emerging Team goes to DNMCC 02. Congratulations. This award is being presented to Punjab University. And lastly, we have the best speaker for the final rounds, which goes to Mariam Fareed from DNMCC 05 from the institution Ziauddin University, Faculty of Law and Politics and Governance. Now we move on to the acknowledgement of the executive body of the Denning Mooting Society. I'd like to invite the entire executive body to please join us on the stage. A huge round of applause for them, everybody. I would now like to call Sir Josefa to present the token of appreciation to our special guest of honor, a huge round of applause, everybody. Now I request the Honourable Chief Guest, Honourable Mr. Justice Muhammad Ali Mazhar, to join us on the stage to announce the winners of the competition.
Ziauddin University is the winner and NUST is the runners-up, sir.
NUST.
Yes, Ziauddin. NUST. Yes, sir. But I think they would recognize that the team code is better. 015 or 0.
Now I have been asked to announce the final and runners-up team. तो आप दिल थाम के बैठिए, सब जो है पहले फाइनल का अनाउंस करूँ. विनर है DNMCC 0 DNMCC 0, फिर एक और 0, इसके बाद 5. ये अभी इनसे पूछने से पता चला कि ये ज़ियाउद्दीन से हैं, ज़ियाउद्दीन यूनिवर्सिटी. और अब रनर्स अप तो आपको पता ही है, वो नस से हैं, उनका है 015. तो आप
Honorable Justice, we request for you to present the token of appreciation to our guests of honors. Mr. Hasan Azhar, the Chairman Executive Committee of Pakistan Bar Council. Mr. Fahim Zia, Member of Sindh Bar Council. Mr. Javed Ahmed Rajput, Vice President of Sindh High Court Bar Cooperative Society. I would now like to call upon Sir Josefa to present the token of appreciation to our guests. As we come to the conclusion of this remarkable event, I would like to extend my sincere gratitude to every esteemed person who graced us with their presence today. Your guidance and encouragement means the world to aspiring advocates like us. To our participants, this is not just the end of a competition, but the beginning of your journey as legal professionals. Keep striving, keep learning, keep pushing the boundaries of advocacy. And with that, it has been a pleasure having you all here with us today. The International Court of Justice is now adjourned. See you all next year.